Hi, Faye.
Good evening. In a massive decision that has come in today, the Supreme Court has ordered the release of NewsClick editor-in-chief and founder Purbir Purkayastha. He's a very senior journalist who's been in jail since October last year on the very stringent anti-terror UAPA law. The most important part for me in that judgment is that the Supreme Court called his arrest and his detention illegal. Where does this leave us here as a democracy, seeing journalists being targeted in this manner? We, as ordinary people, but the law can be used in this way against us in an illegal fashion. And when it's being done, do we have to wait months before we get attention from the Supreme Court, before we get bail? Joining me right now to help us answer these questions is Senior Advocate of the Supreme Court, Sanjay Hegde. Mr. Hegde, good evening and thank you for joining us.
Good evening, Faye.
Would you be kind enough to explain to my audience, Mr. Hegde, the illegality of this arrest and detention as per the Supreme Court?
Well, the Supreme Court has quashed the arrest and the remand primarily on grounds of procedure. It said that Mr. Purkayastha was entitled to be given the grounds of his arrest. The grounds of his arrest were not served on him. Therefore, he could not make an adequate representation against being arrested when he was produced for remand before the magistrate. The police sought to argue that no, this was just a technical error, that grounds in fact had been furnished much later, and that now anyway a charge sheet had been filed, and therefore these minor technicalities did not matter. But the entire law on human liberty is built often on strict adherence to procedure. The Supreme Court found that it was a necessary compliance of the law that had been observed in the breach, and consequently everything that followed thereafter was illegal. So therefore it is quashed both his arrest and his remand and ordered him set free.
Mr. Hegde, do you believe the process is being used as punishment against ordinary citizens in our country? And this is what has happened in this case?
Well, it has routinely been used. See, what is most important is that if a policeman were to pick you up and level any grave charges against you, then it would take God's good time and aided by fierce efforts on the part of your lawyers and the lucky circumstance of getting a good judge's attention before you were actually released. So, after the first calamity, you would need two great miracles to happen. A lot of people do not have access, as a matter of course, to good lawyers. Even in the Purkayastha case, the police argued that, look, there was a legal aid lawyer who was present before the magistrate. So the court asked, he had his own lawyer. You knew who his own lawyer was. Did you inform the lawyer that you had arrested him and you were producing him before a magistrate so that that lawyer could turn up before the magistrate? The answer was no. So I do believe that for the vast mass of people who do not have access to good lawyers and to the courts of law, they often have to just put up with whatever the police tell them. Once they're locked up, then they spend years and years in till somehow in the routine course, finally their matter comes up before a judge and he says, oh, you've been in so long and the trial is not going on. Might as well set you free and we'll see what happens at the end of the trial.
See, I just want to break this down for our audience who's watching, Mr. Hegde. So basically, if the police were to barge into a home, my home, say, for example, and pick me up for whatever charge they feel they have reason to do so, they have to first, within a certain number of hours, present the accused before a magistrate and the magistrate has to agree that there is enough grounds here for the police to gain remand or custody of this individual. Now, it is part of process that a magistrate be given in writing the accusation, the charges being brought against this individual, and the person and that person's lawyer also be given in writing what charges are being brought against this individual. In this particular case, Mr. Purkayasta's case, these charges were not given to him or his lawyer, and he was presented before a magistrate without adequate information and given remand. Is there a level of mischief here, Mr. Hegde? How could the magistrate have given remand?
See, there's a saying that you never attribute malice to that which can be explained by mere routine procedure. The routine procedure is to observe the law in its breach. Oh, yes, sir, we have caught somebody. We are producing him before you. The magistrate just takes a look at you and says, okay, you don't appear to be beaten up. There no particular this one. Oh, these are the charges. Fine. I'll remind you. Mr. Policeman, do you want custody? If the policeman say, no, we don't want custody, but we want to keep him out of trouble, we'll come for custody later. Then the magistrate sends him to judicial custody. After the man goes into judicial custody, only then is a bail application normally entertained. This is what happens. In the Constitution, you have a right to be produced before the nearest magistrate within 24 hours of your detention, and thereafter the magistrate has to pass judicial orders. So what is often being done is that the man is produced before a magistrate. May not be the nearest magistrate, maybe the magistrate who has been given on who's on duty when the other regular people are away, they are on leave or somewhere else, and often out of routine these remands are given. So a procedural safeguard is more or less rendered toothless if it is not fiercely enforced. And despite the Supreme Court saying time and again that the magistracy has to be bold, that the trial courts have to be bold, very often when the person concerned appears to be a person of some substance, some standing, or some weight, as it were, vajan in the vernacular, then magistrates say that it is sometimes safer to agree with the police and let a superior court overrule them than to actually exercise their powers, only to be then whispered about in the corridors of power, saying that this man was compromised, the defense was so and so, and therefore the very influential, and therefore the magistrate got granted the bail or did not agree to a remand. We need a magistracy which enforces the law strictly. A lot of the problems will get sorted there itself.
But Mr. Hegde, I want to also invite and welcome Malika Sarkar, who's become a supporter on our YouTube. Thank you for supporting us, Malika. But Mr. Hegde, between magistrate and Supreme Court, there's an entire process. And that entire process did not notice this illegality. Is it that we will only get justice in Supreme Court?
I hesitate to say that. There have been times when the Supreme Court has said no, but the magistracy has said yes. Even during the emergency, the Supreme Court said that, look, in an emergency, you have no right to life because that's a constitutional right which can be suspended.
Yeah.
Yet, so many high courts had ruled to the contrary. But what I often feel is that bold people, fiercely independent judges, are the backbone of the rule of law. If judges keep looking over their shoulder, if judges keep looking for approval or approbation from the powers that be, they have a promotion to get, they have an elevation to go to, or they have a retirement to be looked after. These are factors that sometimes come into play. And sometimes and this is not me saying, but the Chief Justice of India has also has said things like that the uh, magistrates and the lower courts sometimes are afraid to give bail.
Yeah.
So I've heard of instances where the the courts below have privately told the accused or the lawyers, "Look, I know you guys ought not to be here, but I don't dare give you bail or give you relief. So what I will do is I'll write a truly horrible judgment against you, and appeals court is likely to overturn that." That also happens. I That is why, unless judges are masters of their own courtroom and they call them as they see them and are also given the same latitude in appeal and the same latitude organizationally. See, the trial courts do not have constitutional immunity. If it is said about a particular trial court judge or the other that, in these matters involving these big people, he gives bail, and it is rumored that he has taken money, or he or she has taken money or has traded something. Often these rumors uh, go up the ladder, and then there are sometimes disciplinary inquiries and whatnot. We should truly empower our magistrates and our trial courts, who are the first line and the first point of contact as far as citizens' liberties are concerned. Today, the lower judiciary errs on the side of caution by agreeing with the police. We need a system where, except in cases of violent crime, the trial courts and the magistracy should ask the prosecution, please give us a convincing answer. Why do you need the person under custody? Please give it to us in writing.
Mr. Hegde, in this context, I want to, and one of our audiences also asked the question, ask you about Umar Khalid. It will soon close in on 4 years in jail for this young man. 4 years is a lot for a young man. Again, the trial has not begun. Not a shred of evidence has been presented against him. It's bail hearing after bail hearing after bail hearing. Explain to us, Mr. Hegde, in a democratic, free country like ours, how is this even possible that an individual is in jail for 4 years without a trial?
See, the point is that he has been in custody because he's been charged under the UAPA. In the UAPA, getting bail is very difficult, and there are all these same conditions that the judge has to believe that you are not guilty, and the prosecution has to be given a chance to oppose it. These conditions are often looked at very strictly in the courts below. And as far as the Supreme Court was concerned, somehow there were certain circumstances under which Umar had withdrew his bail application. Faye, can you just give me 1 minute?
Yes. Mr. Hegde, they're taking a call, but just to read out some of the comments that are coming in from our audience right in the meantime. Gaurav, who says the process itself is punishment. We have Abhinav Puri supporting us. Thanks, Abhinav. And Neil Dubey, who says every time the discussion comes up, public protection schemes, the adjective toothless is always used. Kumar says, sir, is the collegium system coming in the way of delivering justice? Mr. Hegde is back. Go ahead, sir.
Yeah. No, the collegium system isn't coming in the way of delivering justice. In fact, what little justice is being delivered, even at the constitutional court level, is probably because of the collegium system and the trade union loyalty is something that judges show each other. Now, there was a judge who had denied who had sent the home minister in an earlier avatar on the police remand. When the gentleman's name came for elevation to the Supreme Court, there was a member of the collegium who said that he would not allow any other name to go without this man's name being first recommended. But it was Justice Akhil Qureshi who retired as the Chief Justice of Tripura without coming to the Supreme Court. So the collegium, the way it fights for the independence of the judiciary, is currently a necessary evil. Because if there is no collegium, if it is only the government that will recommend out of a pool of existing judges, then the choice is likely to be even less independent than it currently is.
Mr. Hegde, the interesting thing about Mr. Purkayastha is that he was also arrested during the term of Ms. Indira Gandhi during the emergency. I think it takes a certain kind of person, but there are some parallels being drawn to that time and this time, isn't there?
Yes, Purkayastha actually has written his autobiography in that brief period of time when these charges were levied against him and before he was arrested. I happened to write a review about his book in The Wire. And the reason that he was arrested during the emergency is also, now in retrospect, quite amusing, but certainly not at that point of time. He was a student of the JNU, and in the JNU, those days, opposing the emergency, there was a strike. At that particular point of time, Maneka Gandhi was a student of JNU as well, and she came home and told Sanjay Gandhi, look, the university is on strike. Sanjay Gandhi then told the police commissioner of Delhi, one P.S. Binder, who no sooner that he left the prime minister's house, went straight to JNU. He was looking for a bearded man called D.P. Tripathi. D.P. Tripathi later became a Rajya Sabha MP of the Nationalist Congress Party. He was looking for D.P. Tripathi, and he arrested the first bearded man he saw, which was Prabir Purkayastha. So he said, you are Tripathi. This fellow said, no, I'm not Tripathi. But he disbelieved him, took him off in an ambassador, and then locked him up under MISA.
For a year.
MISA is preventive detention. Preventive detentions normally last a year, unless they then extended. And even after they realized the mistake, the administration just doubled down. They refused to acknowledge the mistake, and then they continued to detain him, and for a whole year he was detained. So that was the declared emergency, as it were, and when he was a young man. Now he's 70 plus, he's in indifferent health, he's asthmatic, he's diabetic, and he's spent over 7 months inside. I do hope he comes out in good health or in reasonable good health and has time to recover. But both times, being arrested for something that you didn't do and yet taking it as part of life in this country, it requires a certain deal of courage. The least that I could appeal to your viewers is to please go and read his book. It is a modern classic.
All right. So go take a look at that book. Mr. Hegde, if I ask you one more uncomfortable question, there was a declared emergency, and would you say the arrests that we're seeing right now, including the one of Mr. Purkayastha, is an undeclared emergency?
Well, we have come to a stage where you don't need to declare an emergency. Those days, you had to declare it, suspend human rights, fundamental rights, and the courts had to stamp it. Now, very often, if you have hollowed out institutions, if you have bypassed command and control systems, very often, in the old days, somebody got out of hand and the chief minister or the prime minister would possibly tell the home minister that look into it, and the home minister would then tell the police commissioner, and it would go down the chain of command. And there would be some kind of filtration. These days, that kind of filtration is also not around. Very often, commands flow directly to the person on the hot seat. And sometimes commands don't need to be given. There's a brilliant line somebody told me that if you are given a command, you tend to resent it. But if you anticipate a command, you will revel in it. We have a lot of people who go in for anticipatory commands.
Mr. Hegde, thank you so much for answering our questions this evening. Sanjay Hegde is a senior advocate with the Supreme Court. Thankfully, now Mr. Purkayastha will be released from jail after 7 months. Like I said, a very senior journalist, and most journalists have rallied, around him and behind him, except those in mainstream who tend to rally around the government and behind the government. And we hope that this case will be resolved very quickly. Stay with, of course, Beetroot News. For more news and updates, you can download our app. And please remember to like, share, subscribe to our YouTube page. Thank you for watching.